Whereas we, the people of the District of Columbia, desire to become a state of the United States of America, where, like citizens of the other states, we will enjoy the full rights of citizenship of the United States of America, to democracy and a Republican form of government, to enact our own laws governing state affairs, and to voting representation in the United States Congress. Now, therefore, we, the people of the District of Columbia, do adopt this Constitution to be known as the Constitution of the State of Washington, D.C., or Douglas Commonwealth, to establish the means of self-governance of the state of Washington, D.C., and to take our place irrevocably as a state among the states comprising the United States of America.
Bill of Rights. First, freedom of religion, of speech, and of the press. The state of Washington, D.C. shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Second, right to keep and bear arms. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Third, quartering of soldiers. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Fourth, security from unwarrantable search and seizure. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
Equal protection of laws. Upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Rights of accused in criminal proceedings. No person shall be held to answer for a felony offense unless on a presentment or indictment of a grand jury, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against oneself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Right to a speedy jury trial, witnesses, assistance of counsel. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against the accused, to have compulsory process for obtaining witnesses in favor of the accused, and to have the assistance of counsel for defense of the accused. Where the potential sentence exceeds 180 days, the accused shall enjoy the right to trial by an impartial jury. Trial by jury in civil cases. In suits at common law, where the value in controversy shall exceed $5,000 or such greater amount as set by the Superior Court of the State of Washington, D.C., the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the State of Washington, D.C., than according to the rules of the common law. Bails, fines, and punishments. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Reservations of the rights of people. The enumeration in this Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
Section 1, Legislative Power. The legislative power of the State of Washington, D.C. shall be vested in a legislature to be known as the Legislative Assembly, and shall extend to all rightful subjects of legislation within the State of Washington, D.C., consistent with the Constitution of the United States of America and the provisions of this Constitution. Section 2, Composition, Election of Members, Vacancies. The Legislative Assembly shall consist of 21 members. The Speaker of the Legislative Assembly, who shall be elected on a partisan basis at large by the qualified voters of the State of Washington, D.C. 4 members shall be elected on a partisan basis at large by the qualified voters of the state of Washington, D.C. 16 members shall be elected on a partisan basis, 2 by the qualified voters of each of the 8 legislative districts of the state of Washington, D.C. A member of the Legislative Assembly shall be known as a representative. The term of office for representatives shall be 4 years and shall begin at noon on January 2nd of the year following a representative's election. Representatives shall be elected in accordance with the schedule established pursuant to Article 8, Section 1B of this Constitution. The Legislative Assembly may establish its committee structure by resolution.
By a 4/5 vote of representatives, the Legislative Assembly may adopt a resolution of expulsion of one of its representatives if it finds, based on substantial evidence, that the representative took an action that amounts to a gross failure to meet the applicable standards of personal and professional conduct. In the event of a vacancy in the Legislative Assembly of a representative elected from a legislative district, the Board of Elections shall hold a special election in the district. The person elected as a representative to fill a vacancy in the Legislative Assembly shall take office not later than the second day following the day on which the Board of Elections certifies the election, and shall serve as a representative of the Legislative Assembly only for the remainder of the term during which such vacancy occurred, unless re-elected in a subsequent election. In the event of a vacancy in the office of Speaker of the Legislative Assembly not caused by a vacancy in the office of Governor, the Legislative Assembly shall select by majority vote a representative elected at large who shall serve as Speaker of the Legislative Assembly until certification by the Board of Elections of the election of a successor in a special election to fill such vacancy. In the event of a vacancy in the Legislative Assembly of a representative elected at large who is affiliated with a political party, the State Committee of such political party shall appoint a person to fill such vacancy until certification by the Board of Elections of the election of a successor in a special election to fill such vacancy. The person appointed to fill such vacancy shall take office within 2 days of the appointment. With respect to a vacancy of a representative elected at large who is not affiliated with any political party, the Legislative Assembly shall appoint a similarly non-affiliated person to fill such vacancy until certification by the Board of Elections of the election of a successor in a special election to fill such vacancy. Such person, appointed by the Legislative Assembly, shall take office within 2 days of the appointment.
No person shall hold the office of representative of the Legislative Assembly unless that person is a qualified voter of the state of Washington, D.C., resides in and is domiciled in the state of Washington, D.C., and if nominated for election from a particular legislative district, resides in the district from which that person is nominated, has resided and been domiciled in the state of Washington, D.C. for 1 year immediately preceding the day on which the general or special election for such office is to be held, and holds no public office other than representative of the Legislative Assembly, for which that person is compensated in an amount in excess of actual expenses incurred in connection therewith. Nothing in this clause shall prohibit any person, while a representative of the Legislative Assembly, from serving as an official of or delegate to a convention of a political party. The Speaker of the Legislative Assembly shall not engage in any outside employment, whether as an employee or through self-employment, or hold any position other than Speaker of the Legislative Assembly, for which that person is compensated in excess of actual expenses incurred in connection therewith. A representative of the Legislative Assembly shall forfeit the office upon failure to maintain the qualifications required by this section or upon conviction of a felony.
Section 4, Acts, Resolutions, Procedures, Specific Authorities. The Legislative Assembly, to discharge the powers and duties imposed herein, shall pass acts, adopt resolutions, and adopt rules upon a vote of a majority of the members of the Legislative Assembly present and voting, unless a greater proportion of its members is required by this Constitution. Except as provided in Section 4 of this subsection, the Legislative Assembly shall use acts for all legislative purposes. The Legislative Assembly shall hold 2 readings for all acts, except upon declaration by 2/3 of its members of exigent circumstances, in which such act shall only be effective for a period not to exceed 90 days. Resolution shall be used, A, to express simple determinations, decisions, or direction of the Legislative Assembly of a special or temporary character, and to approve or disapprove proposed acts as authorized by an act of the Legislative Assembly, or of a kind historically or traditionally transmitted to the Council of the District of Columbia under the laws of the former District of Columbia. Such resolutions must be specifically authorized by act and must be designed to implement that act. Resolutions may be approved upon single reading and may take effect immediately upon such approval. Proposed acts and proposed resolutions shall be made promptly available to the public. Every act shall be published upon becoming law, and resolutions shall be published promptly after approval by the Legislative Assembly. The Legislative Assembly shall adopt and publish rules of procedure, which shall include provision for adequate public notice of attended actions of the Legislative Assembly. An act adopted by the Legislative Assembly shall be presented by the Speaker of the Legislative Assembly to the Governor, who shall, within 10 calendar days after the act is presented, either approve or disapprove such act. To approve an act, the Governor shall affix the Governor's signature to it, and such act shall become law. To disapprove such act, the Governor shall, within 10 days after it is presented to the Governor, return such act to the Legislative Assembly, setting forth in writing the reasons for such disapproval. If any act so adopted shall not be returned to the Legislative Assembly by the Governor within 10 calendar days after being presented to the Governor, the Governor shall be deemed to have approved it, and such act shall become law unless the Legislative Assembly, when in a recess of 10 days or more, prevents its return, in which case it shall not become law. The Governor, within 10 calendar days after being presented to the Governor shall be deemed to have approved it, and such act shall become law unless the Legislative Assembly, when in a recess of 10 days or more, prevents its return, in which case it shall not become law.
If within 30 calendar days after an act has been timely returned by the Governor to the Legislative Assembly with the Governor's disapproval, 2/3 of the members of the Legislative Assembly present and voting vote to reenact such act. The act shall become law without the Governor's signature. In the case of any budget act adopted by the Legislative Assembly and submitted to the Governor shall have power to disapprove any items or provisions, or both, and approve the remainder. To exercise such disapproval, the Governor shall append to the signed act a statement indicating the items or provisions that the Governor disapproves, and shall, within such 10-day period, return a copy of the act and statement to the Legislative Assembly. If the Governor fails to return any such item or provision so disapproved to the Legislative Assembly within such 10-day period, such item or provision shall be deemed approved. If, within 30 calendar days and after any such budget act has been timely returned by the Governor to the Legislative Assembly, 2/3 of the members of the Legislative Assembly present and voting vote to reenact any such item or provision, it shall become law.
All acts shall become effective and enforceable 60 days after enactment, unless another date is specified in the act or other law. By act, the Legislative Assembly shall have authority to create or abolish any office, agency, department, or instrumentality of the state of Washington, D.C., not established in this Constitution, and to define the powers, duties, and responsibilities of any such office, agency, department, or instrumentality. The Legislative Assembly, or any committee or person authorized by it, shall have the power, as otherwise authorized by the rules of the Legislative Assembly, to investigate any matter relating to the affairs of the state of Washington, D.C., and for that purpose may issue subpoenas and administer oaths to require the attendance and testimony and the production of evidence. In conducting a lawful investigation, the Legislative Assembly or one of its committees may seek enforcement of any subpoena it issues in the Superior Court of the State of Washington, D.C. The Legislative Assembly may, by resolution, call for an advisory referendum upon any matter upon which the Legislative Assembly desires to take action. The majority of the number of non-vacant seats of the Legislative Assembly shall constitute a quorum for the transaction of business. The Legislative Assembly may establish by its rules what number of members constitutes a quorum for holding hearings or voting in a committee of the Legislative Assembly. Each 10 calendar day period referenced in this section excludes Saturdays, Sundays, and legal holidays.
Speaker of the Legislative Assembly. The Speaker of the Legislative Assembly shall be the presiding officer and chief executive officer of the Legislative Assembly. When the office of governor is vacant, the Speaker of the Legislative Assembly shall act in the governor's stead. While acting as governor, the Speaker of the Legislative Assembly shall not exercise any authority as Speaker of the Legislative Assembly or as a member of the Legislative Assembly. While the Speaker of the Legislative Assembly is acting as governor, the Legislative Assembly shall select one of the elected at-large members of the Legislative Assembly to serve as Speaker until the return of the elected Speaker of the Legislative Assembly. Section 6, Legislative Districts. The boundaries of the legislative districts shall be established from time to time, at least decennially, by an act of the Legislative Assembly. Each legislative district shall consist of contiguous territory, be compact in form, and be of substantially equal population to the other legislative districts.
Section 7, Advisory Neighborhood Commissions. The Legislative Assembly shall by act divide the state of Washington, D.C. into neighborhood commission areas, which areas shall be represented by an elected advisory neighborhood commission. Members of each advisory neighborhood commission shall be known as advisory neighborhood commissioners and shall be elected from a single-member district on a nonpartisan basis. No person shall hold the office of advisory neighborhood commissioner unless that person, 1, is domiciled in the state of Washington, D.C. and resides in the single-member district from which that person is nominated, 2, is a qualified voter of the state of Washington, D.C., and 3, has resided and been domiciled in the state of Washington, D.C. for 1 year immediately preceding the day on which the general or special election for such office is to be held. Each advisory neighborhood commission may, 1, advise the Legislative Assembly and the executive branch on matters of public policy, which advice shall be given great weight. 2, employ staff and expend public funds as authorized by the annual budget for the state of Washington, D.C. for public purposes within its neighborhood commission area. And 3, have such other advisory powers and responsibilities as the Legislative Assembly may establish by act. An advisory neighborhood commissioner shall not be compensated in excess of actual expenses incurred in connection with the discharge of his or her duties.
Section 8, Auditor. There is established for the state of Washington, D.C. the Office of the Auditor, to be headed by an auditor who shall be appointed by the Speaker of the Legislative Assembly, subject to the approval of a majority of the Legislative Assembly. The auditor shall serve for a term of 6 years and shall be paid at a rate of compensation as may be established from time to time by the Legislative Assembly, not to exceed the rate of pay of the Speaker of the Legislative Assembly. The auditor may conduct audits and investigations of the accounts and operations of the government of the state of Washington, D.C. in accordance with such principles and procedures and under such rules and regulations as the auditor may prescribe. Such audits and investigations shall include those required by law and such others as may be referred to it by the Legislative Assembly. In the determination of the auditing procedures to be followed and the extent of the examination of vouchers and other documents and records, the auditor shall give due regard to generally accepted principles of auditing, including the effectiveness of the accounting organizations and systems, internal audit and control, and related administrative practices. The auditor shall have access to all books, accounts, records, reports, findings, and other papers, things, or property belonging to or in use by any department, agency, or other instrumentality of the State of Washington, D.C., necessary to facilitate the audit. Release of information by the auditor shall be subject to the restrictions as are applicable to the agency from which the auditor obtained the information. The auditor shall submit audit reports to the Legislative Assembly, the Governor, and other independent executive offices. Such reports shall set forth the scope of the audit and shall include such comments and information as the auditor may deem necessary to keep the Legislative Assembly, Governor, and independent executive offices informed of the operations to which the reports relate, together with such recommendations with respect thereto as the auditor may deem advisable. A. The operations to which the reports relate, together with such recommendations with respect thereto as the auditor may deem advisable. The auditor shall make such reports, together with such other material as the auditor deems pertinent thereto, available for public inspection. The Governor or independent executive offices shall state in writing to the Legislative Assembly, within an appropriate time, what action has been taken to effectuate the recommendations made by the auditor. The auditor may be removed for cause by 2/3 vote of the Legislative Assembly. The appointment of a successor or to otherwise fill a vacancy shall be for a term of 6 years.
Article 2, the Executive Branch. Part 1, Executive Power. The executive power of the State of Washington, D.C. shall be vested in the Governor and the independent executive offices established herein. Part 2, the Governor. Section 1, Election of the Governor. The Governor shall be elected on a partisan basis by the qualified voters of the State of Washington, D.C. for a term of 4 years, beginning at noon on January 2nd of the year following the person's election. The Governor shall be elected in even years when there is no federal presidential election.
Section 2, Qualifications for holding office, vacancy, compensation. No person shall hold the office of governor unless that person, A, is a qualified voter of the State of Washington, D.C., B, resides in and is domiciled in the State of Washington, D.C., C, has resided and been domiciled in the State of Washington, D.C. for 1 year immediately preceding the day on which the general or special election for governor is to be held, and D, is not engaged in any employment, whether as an employee or as a self-employed individual, and holds no public office or position other than employment as governor, for which that person is compensated in an amount in excess of actual expenses incurred in connection therewith, except that nothing in this clause shall be construed as prohibiting such person while holding the office of governor from serving as an official or delegate of a political party. 2. To fill a vacancy in the office of governor, the Board of Elections shall hold a special election at least 70 days and not more than 174 days after such vacancy occurs, unless it determines that such vacancy could be more practicably filled in a special election held on the same day as the next general election to be held in the State of Washington, D.C. The person elected governor to fill a vacancy in the office of governor shall take office on the day the Board of Elections certifies the election, and shall serve as governor for the remainder of the term during which such vacancy occurred, unless re-elected in a subsequent election. When the office of governor becomes vacant, the Speaker of the Legislative Assembly shall become acting governor and shall serve from the date such vacancy occurs until the date on which the Board of Elections certifies the election of the new governor, at which time the acting governor shall again become Speaker of the Legislative Assembly. While the Speaker of the Legislative Assembly is acting governor, that person shall receive the compensation regularly paid the governor and shall receive no compensation as Speaker or representative of the Legislative Assembly.
The governor shall receive compensation payable in equal installments at a rate of pay established by act. The Legislative Assembly shall not reduce the salary of an incumbent governor. Any changes in the governor's compensation upon enactment by the Legislative Assembly shall apply beginning with the next gubernatorial term after the effective date of such act. The governor shall forfeit the office upon failure to maintain qualifications required by this section or upon conviction of a felony. The governor shall be the chief executive officer of the state of Washington, D.C. government. The governor shall be responsible for the faithful execution of the laws of the state of Washington, D.C. and the proper administration of the affairs of the state of Washington, D.C., coming under the governor's jurisdiction or control, including but not limited to the following powers, duties, and functions. The governor may appoint an administrator and chief operating officer who shall serve at the pleasure of the governor, who shall assist the governor in carrying out the governor's functions under this Constitution, and whose salary shall be set by the governor consistent with any applicable law. The governor may designate the officer or officers of the executive branch of the state of Washington, D.C., who may, under periods of the governor's absence from the state of Washington, D.C., or due to the temporary or partial incapacity of the governor, execute and perform the powers and the duties of the governor. The governor shall administer the personnel functions of the executive branch of the state of Washington, D.C., except for the independent executive entities, including all laws relating to the appointment, promotion, duties, discipline, separation, and other conditions of employment of personnel in the office of the governor. Personnel in the departments of the state of Washington, D.C., and members and employees of boards, offices, commissions, and other agencies. The governor shall, through the heads of the administrative boards, offices, commissions, and agencies, supervise and direct the activities of such boards, offices, commissions, and agencies.
The governor may submit proposed acts and resolutions to the Legislative Assembly. The governor may delegate any of the governor's functions other than the function of approving or disapproving acts passed by the Legislative Assembly, or the power to grant pardons to any officer, employee, or agency of the executive office of the governor, or to any director of an executive department who may, with the approval of the governor, make a further delegation of all or a part of such functions, subordinates under that person's jurisdiction. The governor shall be the custodian of the corporate seal of the state of Washington, D.C., and shall use and authenticate it in accordance with the law. The governor shall have the right to be heard by the Legislative Assembly or any of its committees under rules to be adopted by the Legislative Assembly. The governor may issue and enforce administrative orders not inconsistent with this Constitution or with any statute to carry out the governor's functions and duties. The governor may, by reorganization order, reorganize the offices, agencies, and other entities within the executive branch of the government of the state of Washington, D.C., except where such reorganization is inconsistent with statute. The governor shall have plenary power to grant pardons, commutations, and reprieves, and to remit, forgive, or reduce fines and forfeitures for all offenses against the laws of the state of Washington, D.C. To advance the general welfare and provide for public safety, and consistent with federal law, the governor may enter into compacts and agreements with other states and localities, the federal government, and federal instrumentalities, and may enter into agreements with foreign nations, cities, or businesses, provided that any financial obligations of such compacts and agreements shall be approved by the Legislative Assembly under rules to be adopted by the Legislative Assembly.
The governor shall be the primary planning authority for the state of Washington, D.C. The governor shall be the commander-in-chief over the National Guard of the state of Washington, D.C. The governor shall have charge of the administration of the financial affairs of the state of Washington, D.C., except authority assigned by this Constitution to the chief financial officer, and shall have authority to examine and approve all contracts, orders, and other documents by which the state of Washington, D.C. incurs financial or other obligations.
There is established within the executive branch of the state of Washington, D.C., government and independent office of the Attorney General for the state of Washington, D.C. headed by an Attorney General. The Attorney General shall be elected by the qualified voters of the state of Washington, D.C. on a partisan basis for a term of 4 years beginning at noon on January 2nd of the year following that person's election. The term of office of the Attorney General shall coincide with the term of office of the Governor. When the position of Attorney General becomes vacant, the Chief Deputy Attorney General shall become the Acting Attorney General and shall serve until the date the Board of Elections certifies the election of the new Attorney General, at which time the Acting Attorney General shall again become the Chief Deputy Attorney General. While the Chief Deputy Attorney General is Acting Attorney General, that person shall receive the compensation regularly paid the Attorney General and shall receive no compensation as Chief Deputy Attorney General. To fill a vacancy in the position of Attorney General, the Board of Elections shall hold a special election at least 70 days and not more than 174 days after such vacancy occurs, unless it determines that such vacancy could be more practicably filled in a special election held on the same day as the next general election to be held in the state of Washington, D.C. The person elected Attorney General to fill a vacancy in the office of the Attorney General shall take office on the day of which the Board of Elections certified the election and shall serve as Attorney General for the remainder of the term during which such vacancy occurred. The Attorney General is the Chief Law Officer of the state of Washington, D.C., and shall have charge and conduct of all criminal prosecutions of the state of Washington, D.C., and all suits instituted by and against the government thereof. The Attorney General shall possess all powers afforded the Attorney General by the common and statutory law of the state of Washington, D.C., and shall be responsible for upholding the public interest. The Attorney General shall have the power to control litigation and appeals, as well as the power to intervene in legal proceedings on behalf of the public interest. The Attorney General may furnish opinions in writing on the Attorney General's initiative or when requested to do so by the Governor or the Legislative Assembly. There is established within the executive branch of the state of Washington, D.C., government and independent office of the Attorney General for the state of Washington, D.C., headed by an Attorney General. The Attorney General shall be elected by the qualified voters of the state of Washington, D.C., on a partisan basis for a term of 4 years beginning at noon on January 2nd of the year following that person's election. The term of office of the Attorney General shall coincide with the term of office of the Governor. When the position of Attorney General becomes vacant, the Chief Deputy Attorney General shall become the Acting Attorney General and shall serve until the date the Board of Elections certifies the election of the new Attorney General, at which time the Acting Attorney General shall again become the Chief Deputy Attorney General. While the Chief Deputy Attorney General is Acting Attorney General, that person shall receive the compensation regularly paid the Attorney General and shall receive no compensation as Chief Deputy Attorney General. To fill a vacancy in the position of Attorney General, the Board of Elections shall hold a special election at least 70 days and not more than 174 days after such vacancy occurs, unless it determines that such vacancy could be more practicably filled in a special election held on the same day as the next general election to be held in the state of Washington, D.C. The person elected Attorney General to fill a vacancy in the office of the Attorney General shall take office on the day of which the Board of Elections certified the election and shall serve as Attorney General for the remainder of the term during which such vacancy occurred. The Attorney General is the Chief Law Officer of the state of Washington, D.C., and shall have charge and conduct of all criminal prosecutions of the state of Washington, D.C., and all suits instituted by and against the government thereof. The Attorney General shall possess all powers afforded the Attorney General by the common and statutory law of the state of Washington, D.C., and shall be responsible for upholding the public interest. The Attorney General shall have the power to control litigation and appeals, as well as the power to intervene in legal proceedings on behalf of the public interest. The Attorney General may furnish opinions in writing on the Attorney General's initiative or when requested to do so by the Governor or the Legislative Assembly.
The administration, organization, and operation of the Office of the Attorney General shall be under the jurisdiction and control of the Attorney General. The Attorney General's duties shall include supervising and directing the activities of the office, administering the personnel functions of the office, including all laws relating to the appointment, promotion, duties, discipline, separation, and other conditions of employment of personnel, reorganizing the office, and approving contracts, orders, and other documents by which the state of Washington, D.C. incurs financial or other obligations for the Office of the Attorney General. The Attorney General shall receive compensation payable in equal installments at a rate of pay established by Act. The Legislative Assembly shall not reduce the salary of an incumbent Attorney General. Any changes in the Attorney General's compensation upon enactment by the Legislative Assembly shall apply beginning with the next Attorney General's term after the effective date of such act.
There is established within the executive branch of the State of Washington, D.C., government and independent office of the Chief Financial Officer for the State of Washington, D.C., headed by the Chief Financial Officer of the State of Washington, D.C. The Chief Financial Officer for the State of Washington, D.C. shall be appointed by the Governor with the advice and consent by the resolution of the Legislative Assembly. The Chief Financial Officer shall be appointed for a term of 5 years. Any Chief Financial Officer may continue to serve beyond the appointed term until a successor takes office. If there is a vacancy in the office of the Chief Financial Officer as a consequence of resignation, permanent disability, death, or other reason, the Governor shall appoint one of the Deputy Chief Financial Officers to serve as the Chief Financial Officer in an acting capacity. The Governor shall promptly nominate a person to serve as Chief Financial Officer for the remainder of the term during which the vacancy occurred, provided that the Governor shall submit the nomination to the Legislative Assembly for its approval as provided in subsection B of this section. The Chief Financial Officer may be removed only for cause by the Governor, subject to the approval of the Legislative Assembly by a resolution approved by not fewer than 2/3 of members of the Legislative Assembly present and voting. The administration, organization, and operation of the Office of the Chief Financial Officer shall be under the jurisdiction and control of the Chief Financial Officer. The Chief Financial Officer's duties shall include supervising and directing the activities of the office, administering the personnel functions of the office, including all laws relating to appointment, promotion, duties, discipline, separation, and other conditions of employment of personnel, and reorganizing the office.
The Chief Financial Officer shall, under the direction of the Governor, prepare the budgets and financial plans for the State of Washington, D.C. for submission by the Governor to the Legislative Assembly. The Chief Financial Officer shall, 1. Assure that all financial information submitted by the Governor to the Legislative Assembly or for any other official purpose is accurate and complete. 2. Prepare and submit to the Governor and the Legislative Assembly and make public annual fiscal year estimates of all revenue for the State of Washington, D.C. and quarterly re-estimates of the revenues of the State of Washington, D.C. during the fiscal year. 3. Supervise and assume responsibility for financial transactions to ensure adequate control over revenues and resources. 4. Maintain systems of accounting and internal controls designed to provide full disclosure of the impact of the activities of the State of Washington, D.C. government, adequate financial information necessary for management purposes, effective control over and accountability for all funds, property, and other assets of the state of Washington, D.C., and reliable accounting results to serve as the basis for preparing and supporting agency budget requests and controlling the execution of the budget. 5, submit to the Legislative Assembly a financial statement containing such details and at such times as the Legislative Assembly may specify. 6, supervise and assume responsibility for the assessment of all property subject to assessments and taxes, which includes preparing tax maps and providing notice of taxes and special assessments. 7, supervise and assume responsibility for the levying and collection of all taxes, special assessments, licensing fees, and other revenues of the state of Washington, D.C., and receiving all amounts paid to it. 8, maintain custody of all public funds. 9, apportion funds made available so as to prevent deficiencies or a need for supplemental appropriations. 10, certify all contracts and leases prior to execution as to the availability of funds. 11, determine the regularity, legality, and correctness of bills, invoices, payrolls, claims, demands, or charges. 12, supervise and administer all borrowing programs. 13, administer the cash management program of the state of Washington, D.C. 14, administer such payroll and retirement systems as the Legislative Assembly may, by act, assign to it. 15, govern the accounting policies and systems of the state of Washington, D.C. 16, timely prepare yearly, quarterly, and monthly financial reports of the accounting and financial operations of the state of Washington, D.C. 17, prepare fiscal impact statements on such regulations, multi-year contracts, agreements, and proposed legislation as the Governor and Legislative Assembly may require by request or act. 18, certify all collective bargaining agreements and non-union pay proposals as to the availability of funds before submission to the Legislative Assembly, and prepare any financial analysis requested by the Governor of proposed terms or agreements.
The State Board of Education shall consist of 1 member elected from each legislative district and 1 elected at large. By act, the length of terms and provisions for addressing vacancies may be established. A president and vice president of the State Board of Education shall be elected from among the members of the State Board of Education. Powers. The State Board of Education shall be responsible for advising the Governor and Legislative Assembly on educational matters, including state standards, state policies, including those governing special, academic, vocational, charter, and other schools, state objectives, and state regulations. By act, the Legislative Assembly may establish which educational matters shall be subject to the approval of the State Board of Education. Section 4, Board of Elections. The authority to manage and supervise elections, initiatives, referenda, and recalls provided under this Constitution shall be vested in the Board of Elections. The Legislative Assembly shall, by act, provide for the composition, method of selection, and procedures for the Board of Elections to use in carrying out its duties.
The judicial power of the state of Washington, D.C. is vested in the state of Washington, D.C. Court of Appeals, the Superior Court of the state of Washington, D.C., and such other courts as may be established by act. The jurisdiction of the courts shall be established by act. Collectively, these shall be referred to as the State of Washington, D.C. Courts. Section 2. Nomination and appointment to the State of Washington, D.C. Courts. The Governor shall nominate from the list of persons recommended by the State of Washington, D.C. Judicial Nomination Commission and, by and with the advice of the consent of the Legislative Assembly, by resolution, appoint all judges of the State of Washington, D.C. Courts. A judge appointed to the State of Washington, D.C. Courts shall be appointed for a term of 15 years, unless removed or suspended, and upon completion of such term, such judge shall continue to serve until reappointed or a successor is appointed and is sworn in. A judge who is found well qualified by the Commission on Judicial Disabilities and Tenure shall be reappointed.
The Legislative Assembly shall, by law, provide for the composition, method of selection, and procedures for the State of Washington, D.C. Judicial Nomination Commission to use in carrying out its duties under this article. Section 3. Qualification for nomination and appointment, removal, compensation. No person shall be nominated or appointed as a judge of the State of Washington, D.C. courts unless that person has resided and been domiciled in the State of Washington, D.C. for at least 1 year prior to nomination, is an active member of the Unified Bar created pursuant to the rules of the State of Washington, D.C. Court of Appeals and has been active in that bar for at least 5 years, and is recommended to the governor for such nomination and appointment by the State of Washington, D.C. Judicial Nomination Commission. Judges may not be removed or sanctioned for the good faith legal determinations they render. A judge of the State of Washington, D.C. courts shall be removed from office upon a final judgment of conviction of a crime that is punishable as a felony under federal law or that would be a felony in the State of Washington, D.C., or determination following a process established by law of willful misconduct in office, willful and persistent failure to perform judicial duties, any other conduct that is prejudicial to the administration of justice or that brings the judicial office into disrepute, failure to maintain residency in the State of Washington, D.C., or a mental or physical incapacity, including habitual intemperance, that is or is likely to become permanent and that prevents or seriously interferes with the proper performance of that person's judicial duties.
The authority to reappoint, remove, or sanction a judge of the State of Washington, D.C. courts, as provided in this article, shall be vested in a Commission on Judicial Disabilities and Tenure. The Legislative Assembly shall, by law, provide for the composition, method of selection, and procedures for the Commission on Judicial Disabilities and Tenure to use in carrying out its duties under this article. All judges of the State of Washington, D.C. courts shall receive compensation, payable in equal installments at a rate of pay established by act. The Legislative Assembly shall not reduce the salary of judges, any judges in the judge's compensation upon enactment by the Legislative Assembly shall apply after the effective date or the applicability date of such act, whichever is later. Section 4, powers of the State of Washington, D.C. courts. The Superior Court of the State of Washington, D.C. shall have jurisdiction of any civil action or other matter at law or in equity brought in the State of Washington, D.C., and of any criminal case under the law of the State of Washington, D.C. The State of Washington, D.C. Court of Appeals shall have jurisdiction of appeals from the Superior Court or an intermediate appellate court established by statute and to the extent provided by law, to review orders and decisions of the governor, the Legislative Assembly, or any agency of the State of Washington, D.C. The State of Washington, D.C. courts shall also have jurisdiction over any matters granted to the State of Washington, D.C. courts by any other provisions of law. Section 5, designation of chief judges. All chief judges of the State of Washington, D.C. courts shall be designated by the State of Washington, D.C. Judicial Nomination Commission from among the judges of their respective courts in regular active service and shall serve as chief judge for a term of 4 years or until a successor is designated, except that a term as chief judge shall not extend beyond the chief judge's term as a judge of the State of Washington, D.C. courts. A chief judge shall be eligible for redesignation as chief judge.
The Legislative Assembly shall establish by the act of the fiscal year of the State of Washington, D.C. The governor shall prepare and submit to the Legislative Assembly each year at such time as the Legislative Assembly shall direct and shall make available to the public a proposed annual budget for the State of Washington, D.C. government. It shall reflect the actual financial condition of the State of Washington, D.C. government, specify the agencies and purposes for which funds are being requested, and be prepared on the assumption that proposed expenditures for such fiscal year shall not exceed estimated resources from existing sources and proposed resources. Be accompanied by an annual budget message that shall include supporting financial and statistical information for the forthcoming fiscal year and information on the approved budgets and expenditures for the immediately preceding 3 fiscal years. A multi-year financial plan of revenues and expenses, including multi-year operating and capital improvement plans for all agencies, and a summary of the budget for distribution to the general public. The proposed budget and financial plan shall be certified by the Chief Financial Officer as balanced, and the governor shall not forward to the Legislative Assembly a budget that is not balanced. The budget shall identify any new sources of revenue that shall be necessary to balance the budget as submitted. The budget prepared and submitted by the governor shall include, but not be limited to, recommended expenditures at a reasonable level for agencies under the authority of the governor, and expenditures for the Legislative Assembly, the State of Washington, D.C. court system, the Office of the Attorney General, the Office of Chief Financial Officer, the State Board of Education, and the Board of Elections for each such entity.
The governor may prepare and submit to the Legislative Assembly such supplemental or deficiency budget proposals as are necessary, including proposals to increase revenues to meet any such increased expenditure, and may prepare and submit to the Legislative Assembly for approval by resolution proposed reprogrammings of budgeted amounts. The Legislative Assembly may by act designate categories and classes of supplemental and deficiency budget modifications and reprogrammings for which approval by the Legislative Assembly is not required, or for which approval of the Legislative Assembly will be deemed to have occurred upon the expiration of a specified period of time after the governor submits the proposal to the Legislative Assembly. Section 3, Adoption of Budget by Legislative Assembly. The Legislative Assembly, within 77 calendar days after receipt of the budget proposal from the governor and after a public hearing, shall adopt by act the annual budget for the State of Washington, D.C. government. No amount may be obligated or expended by any officer or employee of the State of Washington, D.C. government unless such amount has been approved by act of the Legislative Assembly, and then only according to such act or as otherwise provided in Section 2C of this article. Section 4, Annual Financial Statement and Audits. Within 123 days following the close of the fiscal year, the governor shall submit to the Legislative Assembly a complete and audited financial statement and report for the preceding fiscal year. Section 5, Balanced Budget. The Legislative Assembly shall not approve any budget that would result in expenditures being in excess of all resources that the Chief Financial Officer estimates will be available from all funds available to the State of Washington, D.C. for such fiscal year.
Section 6, Review of Contracts by Legislative Assembly. By Act, the Legislative Assembly may establish which contracts may be subject to its review and approval, provided that the scope of the contract subject to the review of the Legislative Assembly shall no exceed the scope of those contracts that were subject to approval of the former Council of the District of Columbia. Section 7, Emergency and Contingency Reserve Funds. The governor shall deposit into the Emergency Cash Reserve Fund no later than the first day of each fiscal year such an amount as may be required to maintain a balance in the fund of at least 2% of the operating expenditures of the government of the State of Washington, D.C., provided that if the governor uses money from the fund during a fiscal year, the State of Washington, D.C. shall appropriate sufficient funds each fiscal year in the budget process to replenish any amount allocated from the Emergency Reserve Fund during the preceding fiscal year so that not less than 50% of any amount allocated in the preceding fiscal year or the amount necessary to restore the Emergency Reserve Fund to the 2% required balance, whichever is less, is replenished by the end of the fiscal year. Following each such allocation, and 100% of the amount allocated or the amount necessary to restore the Emergency Reserve Fund to the 2% required balance, whichever is less, is replenished by the end of the second fiscal year following each such allocation, provided further that if any amount is allocated from the Emergency Cash Reserve Fund for cash flow management purposes, the governor shall fully replenish the fund in the amount allocated, not later than the earlier of the expiration of the 9-month period that begins on the date of the allocation is made, or the last day of the fiscal year.
The governor may use the Emergency Cash Reserve Fund to provide for unanticipated and non-recurring extraordinary needs of an emergency nature, including for expenses associated with a natural disaster or calamity or state of emergency as declared by the governor. for unexpected obligations of federal law and for cash flow management purposes in an amount of not more than 50% of the balance of the fund, the governor shall deposit into a contingency cash reserve fund not later than the first day of each fiscal year such amount as may be required to maintain a balance in the fund of at least 4% of the operating expenditures of the government of the state of Washington, D.C., provided that the government of the state of Washington, D.C. shall appropriate sufficient funds each fiscal year in the budget process to replenish any amounts allocated from the contingency reserve fund during the preceding fiscal years so that not less than 50% of any amount allocated in the preceding fiscal year or the amount necessary to restore the contingency reserve fund to the 4% required balance, whichever is less, is replenished by the end of the fiscal year following each such allocation, and 100% of the amount allocated or the amount necessary to restore the contingency reserve fund to the 4% of the amount allocated or the amount necessary to restore the contingency reserve fund to the 4% required balance, whichever is less, is replenished by the end of the second fiscal year following each such allocation, provided further that if an amount is allocated from the contingency cash reserve fund for cash flow management purposes, the governor shall fully replenish the fund in the amount allocated not later than the earlier of the expiration of the 9-month period that begins on the date the allocation is made or the last day of the fiscal year.
The governor may use the contingency cash reserve fund to provide for non-recurring or unforeseen needs that arise during the fiscal year, including for expenses associated with unforeseen weather or other natural disasters, unexpected obligations created by federal law, or new public safety, health, welfare, or education needs or requirements that have been identified after the budget process has occurred, for opportunities to achieve cost savings to cover revenue shortfalls experienced by the district government for 3 consecutive months, based on a 2-month rolling average. There are 5% or more below the budget forecast and cash flow management purposes in an amount of not more than 50% of the balanced budget. Section 1, authority to issue and redeem general obligation bonds for capital projects. The state of Washington, D.C. may incur indebtedness by issuing general obligation bonds to refund indebtedness of the state of Washington, D.C. at any time outstanding and provided for the payment of the cost of acquiring or undertaking its ferry capital projects, including paying its share of regional transportation projects. Such bonds shall bear interest payable on such dates at such rate or rates and at such maturities as the governor, subject to the provisions of Section 2, may determine to be necessary to make such bonds marketable. The state of Washington, D.C. may reserve the right to redeem any or all its obligations before maturity in such manner, and it may be such a price as may be fixed by the governor prior to the issuance of such obligations. For purposes of Section 1, capital projects means any physical, public betterment or improvement, the acquisition of property of a permanent nature, or the purpose of equipment or furnishings.
Section 2, contents of borrowing legislative and elections on issuing general obligation bonds. The Legislative Assembly may by act authorize the issuance of general obligation bonds for the purposes specified in Section 1. Such an act shall contain at least provisions: 1, briefly describing each project to be financed by the act; 2, identifying the act authorizing each such project or category of projects; 3, setting forth the maximum amount of debt principal that may be incurred for the projects; 4, setting forth the maximum rate of interest to be paid on such indebtedness; 5, setting forth the maximum allowable maturity for the issue and the maximum debt service payable in any year; authorizing the bonds to be sold at public sale or private sale on a negotiated basis, as determined by the governor to be in the public interest; 7, authorizing the governor to enter into the amend agreements in connection with the bond issue, including the trust indenture; 8, vesting in the trustee under such a trust indenture such properties, rights, powers, and duties in the trust as may be necessary, convenient, or desirable; 9, authorizing the creation of a security interest in the state of Washington, D.C. revenues as additional security for the repayment of the bonds; 10, describing the particular state of Washington, D.C. revenues that are subject to such security interests; 11, prescribing the validity of such security interests; prescribing remedies of the bondholders in the event of a default; and 13, specifying such other covenants, provisions, and conditions necessary to issue the additional bonds as priority bonds. The governor shall publish the enacted act in at least one newspaper of general circulation within the state of Washington, D.C., with a notification that the time with which a suit, action, or proceeding questioning the validity of such bonds may be commenced expires at the end of a 20-day period beginning on the date of the first publication of the notice. Failure to publish the notice or any error in publication shall not impair the effect of the act or the validity of the bonds issued pursuant to the act.
Section 3. Issuance of general obligation bonds. After an act of Legislative Assembly authorizing the issuance of general obligation bonds has taken effect, the governor may issue the general obligation bonds. An issue of the general obligation bonds may be all or any part of aggregate principal amount of bonds authorized by such act. The principal amount of the general obligation bonds of each issue shall be payable in annual installments beginning not later than 3 years after the date bonds and ending not later than 30 years after such date. Section 4. Borrowing to meet appropriations and anticipation of revenues. In the absence of unappropriated revenues available to meet appropriations, the Legislative Assembly may by act authorize the issuance of general obligation notes. In anticipation of the collection or receipt of revenues for a fiscal year, the Legislative Assembly may by act authorize the issuance of revenue anticipation notes. The amount of any general obligation notes originally issued during a fiscal year shall not exceed 2% of the total appropriations for the state of Washington, D.C. for such fiscal year, and the total amount of all revenue anticipation notes outstanding at all time during a fiscal year shall not exceed 20% of the total anticipated revenue of the state of Washington, D.C. that the governor estimates and the chief financial officer certifies will be credited to the state of Washington, D.C. during the fiscal year in which the bonds will be issued.
Any general obligation note issued under subsection A of this section, or any revenue anticipated note issued under subsection B of this section, as authorized by an act of the Legislative Assembly, may be renewed. Any such note, including any renewal of such a note, shall be due and payable no later than the last day of the fiscal year, occurring immediately after the fiscal year during which the act authorizing the original issuance of such note takes effect. Special tax. Any act of the Legislative Assembly authorizing the issuance of general obligation bonds shall provide for the annual levy of a special tax or charge, if necessary. Such tax or charge shall be levied without limitation as to rate or amount, in the amounts that, together with other state of Washington, D.C. revenues available and applicable, will be sufficient to pay the principal and the interest on such general obligation bonds as they become due and payable. Full faith and credit of the State of Washington, D.C. pledge. The full faith and credit of the State of the Washington, D.C. pledge for the payment of the principal of and interest on any general obligation bond or note issued under this article, whether or not such pledge is stated in which bond or note or in the act authorizing the issuance of such bonds or note.
Section 7. Payment of the general obligation bonds and notes. In each annual budget, the Legislative Assembly shall provide sufficient funds to pay the principal of and interest on all general obligation bonds or notes due and payable during such fiscal year. The governor shall ensure that the principal and interest on all general obligation bonds and notes issued under this article are paid when due, including by paying such principal and interest from funds not otherwise legally committed. All amounts obligated or expended by the State of Washington, D.C. for the payment of principal of interest on or redemption premium for any general obligation bonds issued under this article or issued before the effective date of this Constitution are not subject to appropriation. Section 8. Review bonds and other obligations. The Legislative Assembly may by act or resolution authorize the issuance of revenue bonds, notes, or other obligations, including refunding bonds, notes, or other obligations. 2. Borrow money to finance or assist in the financing or refinancing of undertaking in the areas of housing, health, transit, utilities, preschool, primary, secondary, vocational, adult, rehabilitative, reentry, and higher education, educational loans, facilities for culture, sports, mass commuting, sewage disposal, solid waste disposal, recycling or reuse, hazardous waste disposal, or local district heating or cooling, or the local furnishing of energy or water, manufacturing, and any other undertaking that the Legislative Assembly determines will contribute to the health, education, safety, or welfare of the creation or preservation of jobs for the residents of the state of Washington, D.C., or to the economic development of the state of Washington, D.C., in any facilities or property, real or personal, used in connection with or supplementing any of the foregoing. Any such financing or refinancing may be affected by loans made directly or indirectly to any individual or legal entity, by the purchase of any mortgage, note, or other security, or by the purchase, lease, or sale of any property.
Any revenue, bond, note, or other obligation issued under paragraph 1 of this subsection shall be a special obligation of the state of Washington, D.C., and shall be a negotiable instrument. Any revenue, bond, note, or other obligation issued under paragraph 1 of this subsection shall be paid and secured as to principal, interest, and any premium, as provided by the act or resolution of the Legislative Assembly authorizing the issuance of such bond, note, or other obligation. Any act of the Legislative Assembly authorizing the issuance of such bond, note, or other obligation, or any delegation of such authority, may provide for A, the payment of such bond, note, or other obligation from any available revenues, assets, or property, and B, the securing of such bond, note, or other obligation by the mortgage of real property or the creation of any security interest in available revenues, assets, or other property.
In authorizing the issuance of any revenue bond, note, or other obligation under paragraph 1 of this subsection, the Legislative Assembly may authorize the governor to enter into any agreement concerning the acquisition, use, or disposition of any funds or property. Any such agreement may create any security interest in any funds or property, may provide for the custody, collection, security, investment, and payment of any funds, including any funds held in trust, for the payment of such bond, note, or other obligation, may mortgage any property, may provide for the acquisition, construction, maintenance, and disposition of the undertaking financed or refinanced using the proceeds of such bond, note, or other obligation, and may provide for the doing of any act or the refraining from doing any act that the state of Washington, D.C. has the right to do in the absence of such agreement. Any such agreement may be assigned for the benefit of or made a part of any contract with any holder of such revenue bond, note, or other obligation issued under paragraph 1 of this subsection. Any security interest created under subparagraph A of this paragraph shall be valid, binding, and perfected from the time such security interest is created, with or without the physical delivery of any funds or any other property, and with or without any further action. Such security interest shall be valid, binding, and perfected, whether or not any statement, document, or instrument relating to such security interest is recorded or filed. The lien created by such security interest is valid, binding, and perfected with respect to any individual or legal entity having claims against the state of Washington, D.C., whether or not such individual or legal entity has notice of such lien. Any funds of the state of Washington, D.C., held for the payment or security of any revenue bond, note, or other obligation issued under paragraph 1 of this subsection, whether or not such funds are held in trust, may be secured in the manner agreed to by the state of Washington, D.C., and any depository of such funds. Any depository of such funds may give security for the deposit of such funds. The following obligations and expenditures by the State of Washington, D.C. shall not be subject to appropriations. All amounts, including the amount of any accrued interest or premium, obligated or expended from the proceeds of the sale of any revenue bond, note, or other obligation issued under this section, or issued before the effective date of this Constitution. All amounts obligated or expended for the payment of principal of, interest on, or redemption premium for, or to secure any bonds issued under this section or issued before the effective date of this Constitution, and all amounts obligated or expended pursuant to commitments made in connection with the issuance of a revenue bond, note, or other obligation for repair, maintenance, and capital improvements relating to undertakings financed through any revenue bond, note, or other obligation issued under this section or issued before the effective date of this Constitution.
Any and all such bonds, notes, or other obligations shall not be general obligations of the State of Washington, D.C., shall not be a pledge of or involve in faith and credit or the taxing power of the State of Washington, D.C., shall not constitute a debt of the State of Washington, D.C., and shall not constitute lending of the public credit for private undertakings. Any and all such bonds, notes, or other obligations shall be issued pursuant to an act or resolution of the Legislative Assembly without the necessity of submitting the question of such issuance to the registered qualified voters of the State of Washington, D.C. for approval or disapproval. Any act or resolution of the Legislative Assembly authorizing the issuance of revenue bonds, notes, or other obligations under paragraph 1, subsection A of this section may, 1. Briefly describe the purpose for which such bonds, notes, or other obligations are being issued. 2. Prescribe the form, terms, provisions, manner, and method of issuing and selling, including sale by negotiation or by competitive bid, such bonds, notes, or other obligations. 3. Provide for the rights and remedies of the holders of such bonds, notes, or other obligations upon default. 4. Prescribe any other details with respect to the issuance, sale, or securing of such bonds, notes, or other obligations. 5. Authorize the governor to take any actions in connection with the issuance, sale, delivery, security, and payment of such notes, bonds, or other obligations, including the prescribing of any terms or conditions not contained in such act or resolution of the Legislative Assembly. The Legislative Assembly may by act delegate to any independent instrumentality of Washington, D.C. the authority of the Legislative Assembly under Section A of this section to issue revenue, bonds, notes, or other obligations to borrow money for the purposes described in subsection A of this section.
Section 9. Limitations on borrowing and spending. No general obligation bonds, other than bonds to refund outstanding indebtedness, shall be issued during any fiscal year in an amount that would cause the amount of principal and interest required to be paid both serially and into a sinking fund in any fiscal year on the aggregate amounts of all outstanding general obligation bonds and such Treasury loans to exceed 17% of the State of Washington, D.C. revenues, less any fees or revenues directed to servicing, revenue bonds, any revenues, charges, or fees dedicated for the purpose of water and sewer facilities, including fees or revenues directed to servicing or securing revenue bonds issued for such purposes, retirement contributions, revenues from retirement systems, and revenues derived from the sale of general obligation or revenue bonds that the governor estimates and the chief financial officer certifies will be credited to the State of Washington, D.C. during the fiscal year in which the bonds will be issued. The 17% limitation specified in subsection A of this section shall be calculated in the following manner. Determine the dollar amount equivalent to 17% of the State of Washington, D.C. revenues as specified in subsection A of this section. Determine the actual total amount of principal and interest to be paid in each fiscal year for all outstanding general obligation bonds, less the allocable portion of principal and interest to be paid during the year on general obligation bonds of the District of Columbia issued prior to October 1, 1996 for the financing of Department of Public Works, water and sewer utility administration capital projects. And such Treasury loans determine the amount of principal and interest to be paid during each fiscal year over the term of the proposed general obligation bond or such Treasury loan to be issued. And if in any one fiscal year the sum arrived at by adding paragraphs 2 and 3 of this subsection exceeds the amount determined under paragraph 1 of this subsection, then the proposed general obligation bond or such Treasury loan in paragraph 3 of this paragraph cannot be issued. Section 10, tax exemption. Bonds and notes issued pursuant to this article and the interest thereon shall be exempt from all taxes of the state of Washington, D.C. except estate, inheritance, and gift taxes.
Section 11, legal investments. Notwithstanding any restriction on the investment of funds by the fiduciaries contained in any other law, all domestic insurance companies, domestic insurance associations, executors, administrators, guardians, trustees, and fiduciaries within the state of Washington, D.C. may legally invest in any sinking funds, money, trust funds, or other funds belonging to them or within their control in any body issued pursuant to the title. It be the purpose of sections to authorize investments in such bonds of notes of all sinking insurance, retirements, compensations, pensions, and trust funds.
The term initiatives mean the process by which the registered qualified electors of the state of Washington, D.C. may propose laws, accept laws appropriating funds or having the effect of authorizing discrimination, and present such proposed laws directly to the registered qualified electors of the state of Washington, D.C. for their approval. The term referendum means the process by which the registered qualified electors of the state of Washington, D.C. may repeal or ratify the acts of the Legislative Assembly, except emergency acts, acts levying taxes, acts appropriating funds, acts having the effect of prohibiting discrimination, or advisory referendum. The term recall means the process by which the registered qualified electors of the state of Washington, D.C. may call for the holding of an election to remove or retain an elected official prior to the expiration of that official's term. Section 2, process. An initiative or referendum may be proposed by the presentation to the Board of Elections of a petition containing the signatures of 5% of the registered voters in the state of Washington, D.C., provided that the total signatures submitted shall include 5% of the registered voters in a majority of the legislative districts. The latest official count of registered voters by the Board of Elections that was issued 30 or more days prior to the submission of the signatures for any particular initiative, referendum, or recall petition shall be used for computing the signature requirements of this article.
Section 3, submission of measure at election. The Board of Elections shall submit an initiative of referendum measure without alteration at the next statewide general, primary, or special election held at least 90 days after the measure is received. The Board of Elections shall hold an election on a recall petition within 114 days of its receipt of a petition. If a previously scheduled general, primary, or special election will occur between 54 and 114 days of its receipt of a recall petition, the Board of Elections may present the recall petition at the election. Section 4, rejection of measure. If a majority of the registered qualified electors voting on a referred act vote to disapprove the act, such action shall be deemed a rejection of the act or that portion of the act on the referendum ballot. No action may be taken by the Legislative Assembly with regard to the matter presented at the referendum for 365 days following the date of the Board of Elections certification of the vote concerning the referendum. Section 5, approval of measure. If a majority of the registered qualified electors voting in a referendum approve of an act or adopt legislation by an initiative, then the adopted initiative or act approved by the referendum shall become law upon the certification of the vote by the Board of Elections on such initiative or act. Section 6, short title and summary. The Board of Elections shall propose a short title and summary of the initiative and referendum matter that shall accurately reflect the intent and meaning of the proposed referendum or initiative.
Section 7, recall process. Any elected official of the state of Washington, D.C. government elected on a partisan basis may be recalled by the registered qualified electors of the election district or districts from which that official was elected. A recall shall be proposed by the following with the Board of Elections of a petition demanding the recall of the elected official, signed by 10% of the registered qualified electors in the elected official's election district or districts, including 10% of the registered qualified electors and a majority of the election districts for the statewide elected official. Section 8. Time limits on initiation of recall process. The process of recalling an elected official may not be initiated within the first 365 days nor the last 365 days of the official terms of office. Nor may the process be initiated within 1 year after a recall election has been determined in the official's favor. Section 9. When an official is removed, filling of vacancies. An elected official is removed from office if a majority of the qualified electors voting in the election vote to remove the official. The vacancy created by such recall shall be filled in the same manner as other vacancies as provided in this Constitution.
Section 1. Openness and transparency. The government of the state of Washington, D.C. shall operate on principles of openness, transparency, and democratic participation. Specific obligations regarding participation and transparency may be established by act of the Legislative Assembly and administrative orders of the governor. Section 2. Construction of Constitution. To the extent that any provisions of this Constitution are inconsistent with the provisions of any other laws of the state of Washington, D.C., the provisions of this Constitution shall prevail and shall be deemed to supersede the provisions of such laws. The use of partisan or nonpartisan with respect to elections under Articles 1 and 2 shall determine only whether the name of a political party may appear next to the name of a candidate on the ballot, but shall not limit the authority of the Legislative Assembly to establish any type of primary or runoff system it may find appropriate. In interpreting this Constitution, the courts are not bound by the interpretation given by federal courts to identical or similar language in the United States Constitution, but shall interpret this Constitution in light of its purposes and laws, values, and traditions of the state of Washington, D.C. Section 3, Constitution Amending Procedure. The Constitution may be amended by an act passed by the affirmative vote of 2 to 3 of the members of the Legislative Assembly and ratified by a majority of the qualified voters who vote in a ratification referendum. Ratified constitutional amendments take effect either the date of the Board of Elections certifies the ratification or the date prescribed by the amendment, whichever is later.
Section 4, Constitutional Convention. No later than the second anniversary of the date of the admission of the state of Washington, D.C. as a member of the Union, the Legislative Assembly shall call for a constitutional convention to assess the functionality of this Constitution in the transition from a federal district to statehood. The Legislative Assembly shall, by act, establish for the Constitutional Convention procedures for the convention that shall include the election process for delegates to the Constitutional Convention to be comprised of an equal number of delegates from each legislative district. The Legislative Assembly shall appoint a Constitutional Convention Commission comprised of legal and subject matter experts with the purpose of preparing comprehensive recommendations and advice to the Constitutional Convention delegates on the subjects established by the Legislative Assembly. Any amendment resulting from such a Constitutional Convention shall be ratified by a majority of the qualified voters who vote in a ratification referendum. Section 5, Oath of Office. The representatives of the Legislative Assembly, the governor, all executive and judicial offices, and the advisory neighborhood commissioners shall be bound by oath or affirmation to support this Constitution, the laws of the state of Washington, D.C., and the Constitution of the United States of America. Section 6, Effective Date. This Constitution shall take effect upon passage of an admission act to admit Washington, D.C. as a state of the United States of America with the same rights as other states, unless otherwise provided therein.
Section 1, Transfer of Offices. The Council of the District of Columbia and the offices of council members, chairman of the council, and mayor are abolished as of the effective date of this Constitution, to provide continually during the transition from the government of the District of Columbia to the state of Washington, D.C., the members of the council, the
the chairman of the council, the mayor, the attorney general, and members of the State Board of Education and advisory neighborhood commissions in office as of the effective date of this Constitution shall be deemed representatives of the Legislative Assembly, Speaker of the Legislative Assembly, Governor, Attorney General, and members of the State Board of Education and advisory neighborhood commissions, respectively, in accordance with current boundaries until the expiration of the term of office each such individual held immediately prior to the effective date of this Constitution. Vacancies in these offices occurring during the holdover term shall be filled as provided in Articles 1, 2, and 6. New representatives of the Legislative Assembly shall be elected on the same schedule as existing council members of the District of Columbia. The Board of Education shall hold elections for newly created positions in the Legislative Assembly at least 60 days and not more than 120 days after the effective date of this Constitution, unless it determines that such positions could be more practically filled in a special election held on the same day as the next primary or general election to be held in the state of Washington, D.C. The Legislative Assembly shall, by act, establish the election schedule for all newly created positions, provided that such act ensures a staggered schedule, including between representatives for the same legislative district. The individual serving as District of Columbia Auditor as of the effective date of this Constitution shall be deemed to have been appointed as Auditor under Article 1 for a term to expire as of the date of expiration of the term to which he or she was appointed.
Positions previously held on boards, commissions, and regional bodies by members of the District of Columbia, the chairman of the council, or the mayor shall be held after the effective date of this Constitution by representatives of the Legislative Assembly, the Speaker of the Legislative Assembly, and the Governor, respectively, to the extent consistent with this Constitution. For boards and commissions, members not federally appointed and in office as of the effective date of this Constitution shall continue to serve until the expiration of that term of office held on the effective date of this Constitution. The terms of federally appointed members to any District of Columbia board or commission shall expire on the 90th day from the effective date of this Constitution unless otherwise provided by law, and no vacancies shall be deemed to be created by the abolition of these positions unless the Governor or Legislative Assembly creates a new position on the board or commission. The individual serving as Chief Financial Officer as of the effective date of this Constitution shall be deemed to have been appointed as Chief Financial Officer under Article 2 for a term to expire on July 1st of the year in which this individual's previously extant term would have expired.
Section 2, Continuation of State of Washington, D.C. Court System. To provide continuity during the transition from the government of the District of Columbia and the State of Washington, D.C., the judges of the Superior Court of the District of Columbia and the District of Columbia Court of Appeals, appointed as of the effective date of this Constitution, shall be deemed judges of the Superior Court of the State of Washington, D.C. and the State of Washington, D.C. Court of Appeals, respectively, until the expiration of that term of office held immediately prior to the effective date of this Constitution. The District of Columbia Court of Appeals, the Superior Court of the District of Columbia, the Judicial Nomination Committee, and the Commission on Judicial Disability and Tenure shall continue subject to the provisions of Article 3 of this Constitution. Any changes in the judge's compensation upon enactment by the Legislative Assembly shall apply after the effective date or the applicability date of such act, whichever is later. The term and qualifications of any judge of any District of Columbia court appointed prior to the effective date of this Constitution shall not be affected by the provisions of Article 3 of this Constitution, No provision of this Constitution shall be construed to extend the term of any such judge. Judges of the State of Washington, D.C. courts appointed after the effective date of this Constitution shall be appointed according to Article 3. Nothing in this Constitution shall be construed to amend, repeal, or diminish the duties, rights, privileges, or benefits accruing under Sections 1561 through 1571 of Title 11 of the District of Columbia Code, dealing with retirement, or to authorize a decrease of the level of compensation of the judges of the District of Columbia courts as of the effective date of this Constitution. The compensation received by judges of the State of Washington, D.C. courts shall not be diminished during their continuance in office.
Section 3. Pending actions and proceedings. All existing writs, actions, suits, judicial and administrative proceedings, civil or criminal liabilities, prosecutions, judgments, sentences, orders, decrees, appeals, causes of actions, contracts, claims, demands, titles, and rights shall continue unaffected except as may be modified in accordance with the provisions of this Constitution. The State of Washington, D.C. shall be the legal successor to the District of Columbia in all matters. Section 4. Laws in force and prior powers. Acts of the Council of the District of Columbia preceding the effective date of this Constitution and the convening of the Legislative Assembly shall be considered valid as if they were enacted by the Legislative Assembly. Upon the effective date of this Constitution, all of the laws then in force in the District of Columbia, including regulations and mayor's orders, shall become the laws of the State of Washington, D.C. and continue in force and effect throughout the State of Washington, D.C., except as modified by the State of Washington, D.C. Admission Act or by this Constitution, or as thereafter modified in accordance with this Constitution. All powers previously vested in the Council of the District of Columbia by Congress through the District of Columbia Home Rule Act, to the extent not consistent with this Constitution, and to the extent not thereafter having been transferred or repealed, shall be vested in the Legislative Assembly in accordance with the provisions of this Constitution. The powers possessed by the respective advisory neighborhood commissions for the District of Columbia on the day prior to the effective date of this Constitution shall be possessed by the advisory neighborhood commissions for the State of Washington, D.C. on the effective date of this Constitution, to the extent not inconsistent with this Constitution, and to the extent not thereafter modified or repealed in accordance with this Constitution.
Except as otherwise provided in this Constitution, all functions previously granted to or vested in the Mayor of the District of Columbia through the District of Columbia Home Rule Act, to the extent not inconsistent with this Constitution, and to the extent not thereafter having been transferred or repealed, shall be vested in the office of the Governor in accordance with the provision of this Constitution. The annual compensation of the Speaker of the Legislative Assembly and representatives, the Governor, the Attorney General, the Chief Financial Officer, the judges of the Superior Court of the State of Washington, D.C., and the State of Washington, D.C. Court of Appeals on the effective date of this Constitution shall be the annual compensation provided to the chairman and members of the council, the mayor, the Attorney General, the Chief Financial Officer, and the judges of the Superior Court of the District of Columbia and the District of Columbia Court of Appeals immediately prior to the effective date of this Constitution. The powers possessed by the Attorney General for the District of Columbia on the day prior to the effective date of this Constitution shall be possessed by the Attorney General for the State of Washington, D.C. upon the effective date of the Constitution, to the extent not inconsistent with this Constitution, and to the extent not thereafter having been transferred or repealed.
Section 5, Personnel Rights. Nothing in this Constitution shall be construed as affecting the rights under the District of Columbia law of employees of the State of Washington, D.C. who were employed by the District of Columbia government prior to the effective date of this Constitution, to personnel benefits including but not limited to pay, tenure, leave, retirement, health and life insurance, and employee disability and death benefits, or regulations adopted pursuant thereto and applicable to such officers and employees immediately prior to the effective date of this Constitution, provided that all such benefits shall therefore be subject to modification by act or regulation. Section 6, Debts, Assets, Records. The debts and liabilities of the District of Columbia as effective date of this Constitution shall be assumed by the State of Washington, D.C., and debts owed to the District of Columbia shall be collected by the State of Washington, D.C. Assets and records of the District of Columbia shall become property of the State of Washington, D.C.
Section 7, Residency and Qualifications. Residence, voter registration, or other qualifications under the District of Columbia may be used toward the fulfillment of corresponding qualifications required by this Constitution. Section 8, Adjustments. The Governor is authorized and empowered to enter into an agreement or agreements concerning the manner and method by which amounts owed by the State of Washington, D.C. to the United States or by the United States to the State of Washington, D.C. shall be ascertained and paid. Section 9, Voting Rights. Any person who resides in any area which was a part of the District of Columbia immediately prior to the admission to the State of Washington, D.C., but which is not included within the boundaries of the State of Washington, D.C., may, at the person's option, be deemed to be a resident of the State of Washington, D.C. for purposes of voting in a State of Washington, D.C. election, unless that person claims residency in another state for voting purposes.